Good morning, everyone. This is John Collins coming to you today from my coaching office here near Detroit, Michigan, with a special edition of Crime in the Courtroom. We have breaking news coming out of the Oregon Court of Appeals, which has issued what will certainly be regarded as a controversial opinion pertaining to the forensic laboratory practice of conclusively identifying a specific firearm as having fired one or more cartridge cases recovered by crime scene investigators, for example, at the scene of a shooting. So, very quickly, for some of you in our audience who are not forensic experts, excuse me, we are talking here about a situation where a firearm is used allegedly in the commission of a crime. The gun in this case is a semi-automatic pistol in which unfired ammunition is loaded into a magazine. The gun is put into battery, which means that an unfired cartridge is loaded into the gun's chamber and will fire if the trigger is pulled. And so a cartridge is a term that we use to describe an unfired unit of ammunition, which is comprised of a cartridge case, oftentimes made of brass that houses the gunpowder, has a bullet seated over the gunpowder at the muzzle end of the cartridge, and then at the breech or back end of the cartridge case is a primer. And when the primer is stuck by the firing pin, it creates a small detonation that shoots a flame into the powder, causing the powder to ignite and expand, which then propels the bullet down the barrel and ultimately downrange. Now, there's a lot going on during this process that leaves patterns of microscopic tool marks, as we call them, on the surface of the bullet and on the surface of the cartridge case, which the cartridge case is usually ejected from the firearm and will land on the ground not far from where the shooter is standing, wherever that is. So if police arrest a suspect who has a gun in his or her possession, they will send the gun to a forensic science laboratory to see if the experts there can come to a conclusion as to whether or not the firearm did or did not, in fact, shoot whatever bullets or cartridge cases are recovered by police. This is a practice that has been used, tested, challenged, researched, and scrutinized for more than 125 years. And that is no small thing. In fact, the first scientific literature published in the United States on firearm identification appeared in the Buffalo Medical Journal, of all places. That was in 1900 in an article titled The Missile and the Weapon. This is a pretty well-known article amongst individuals in the firearm and toolmark community. So what we now see coming out of Oregon is a ruling in a case in which an Oregon forensic examiner, I believe this was the Oregon State Police, identified cartridge cases as having been fired in a firearm possessed by the defendant. The court, when it went to the appellate court, categorically found that the method of linking spent cartridge cases to a particular firearm failed to meet the scientific validity standards provided under Oregon's rules of evidence. More specifically, the forensic examiner in this case testified reportedly that the shell casings, as they were called in the case, we call them cartridge cases, that were recovered from the crime scene matched a handgun based on the visual and microscopical comparisons that are common to this kind of analysis. However, the court observed that this quote-unquote matching, which is a term that we really don't use much in forensic science anymore, involved no rigorous empirical methodology. Rather, it relied heavily on the examiner's subjective judgment based on training and experience. And I will go ahead and include a link to the ruling in my program notes. So if you're listening to this and you're not subscribed to receive our program notes, what you can do is go to criticalvictories.com and then just click the subscribe option to make sure you get a copy of the program notes. And I promise we don't spam you, and we keep your contact information secure. You have my word on that. So what does this all mean? Well, it is going to be upsetting to a lot of forensic firearm and toolmark examiners out there, but the impact doesn't just end there, because firearm and toolmark identification is one of a category of forensic disciplines that are known as the pattern identification disciplines. So this This also includes latent print, or what's often called fingerprint comparison, shoe and tire impression analysis, handwriting analysis, fracture analysis, such as, when I say fracture analysis, such as piecing together a fragment of a rear view mirror, let's say, that is found at the scene of a hit and run accident, and then being able to show that that fragment of the mirror came from the suspect driver's car, which has a broken rear view mirror, simply by piecing together the fragment to the original mirror. If you want to do a quick experiment on this, anybody can quickly take a piece of paper and tear it in half, and then just put the tear together, realign it, and put the piece back together like puzzle pieces. And what you'll come away with from doing this exercise, as we've talked about on a previous episode, is that you could repeat the tearing of paper 1 trillion times, and you would not be able to perfectly replicate the tear. And we'll talk a little bit more about where that claim, where that assertion comes from. But for right now, this invites a really important question that is central to any conversation or legal proceeding related to the scientific foundations of the pattern identification disciplines, including firearm identification. And that question is this: what is the true scientific basis, for example, of saying that you cannot replicate the tearing of a sheet of paper? Right? There's no college courses called paper tearing analysis. There are no research studies that have been done, at least not that I'm aware of, in which scientists used, federal grant funds to study the unique contours of paper tears. Yet, many criminal cases have been solved in part based on the ability of a forensic expert to conclude that a page was ripped, for example, from a notebook, or a phone number was torn away from an original sheet of paper. But how can you do that if there is no apparent scientific foundation? What is then the foundation of firearm identification, or latent print identification, or footwear and tire impression identification? Well, one of the challenges of exploring this question, and it's an important question, is that you can have two competing propositions be true at the same time. So yes, without question, firearm and tool mark identification is an area of specialized knowledge and practice that is reliable, and it has been reliable for over a century, period. End of story. And yes, this field of endeavor has been researched and studied and scrutinized, as I said a moment ago, over the course of its entire existence, and it continues to thrive. It continues to be useful to our courts, and it continues to help the triers of fact in both criminal and civil proceedings to understand the evidence in a particular case and to resolve whatever kind of dispute is before the court. So to my forensic colleagues out there, and clients and friends, please resist the temptation to be angry over this ruling that just came out of Oregon. It doesn't change anything. Firearm and tool mark identification, as well as the other pattern identification disciplines, are not going anywhere. They are routinely and reliably providing critical assistance to our courts, and it's not going to change. And the basis of the findings from these particular experts are heavily rooted in both academic and applied research. So all is well. All is well. Now, even though what I just said about the pattern identification disciplines is true, any individual judge in any individual criminal case may decide that he or she is not satisfied that one of the parties has sufficiently established the scientific foundations for whatever forensic tests are to be presented in court. It's not the job of the judge to do the attorney's work for them. So if the prosecution, for example, wants to present a forensic identification of a fired cartridge case as having been discharged inside of a specific firearm, then the prosecution, through its witnesses, has to establish that foundation. A century's worth of practice and research are not necessarily good enough. You have to establish the foundation in this case, right now, today. And if the judge feels that the arguments against the admission of the evidence are more compelling, then that evidence might not be admitted. And the judge has that prerogative. The judge has that option, as long as it's justifiable. So even with all of the history and the experience behind it, the lawyers still have to do their jobs. The prosecution has to make the case that the evidence is reliable, and the defense has to challenge it on behalf of the client or on behalf of the defendant. If the prosecution fails to establish that foundation, it's not the judge's job to say, well, yeah, you did a lousy job of presenting the evidence, but I know through my own understandings that firearm identification is a legitimate science or field of endeavor, so I'm going to allow it anyway. I'm going to allow it anyway. Now, I'm sure that many judges over the decades have admitted many different kinds of forensic evidence into court, many different kinds of forensic testimony, even though one of the parties at trial may have done a lousy job of establishing the underlying credibility. I'm sure of it. But from time to time, you're going to get judges that just are not in the mood to give any leeway, and they have that right. And we have to respect it. And it appears from what we can tell that this is what happened at the Oregon Court of Appeals. They were not in the judicial mood to grant deference to forensic evidence that they felt had not been sufficiently presented. And please keep in mind here, especially you expert witnesses out there who might be, I don't know, let's say newer to the criminal justice system. These kinds of rulings are not new, and they are not an indictment of entire fields of endeavor, even though activists like to characterize it as such. It's not. Instead, what it is an indictment of that particular evidence in that particular case, in that particular courtroom, nothing else. So this notion that gets, reported in the newspapers after these kinds of rulings, that this is a sweeping indictment of a forensic discipline and will have earth-shattering implications in future cases, is not even remotely close to being true. That's what innocence activists and certain advocates of the defense bar especially want you to believe, because they're going up against this kind of evidence in the courtroom, and they want to establish the credibility of their counter arguments. That's how it works. But it's just not true that these are sweeping indictments, and they know it. So what we had in Oregon was one case in which the defense happened to do a really good job, as far as we can tell, of challenging some of the prosecution's evidence. And the prosecution didn't measure up to the standards that the appellate court felt were material to the evidence and to the case. I really doubt that this case is going to rise any higher, because the United States Supreme Court has already ruled on these issues, particularly in Daubert versus Merrill Dow Pharmaceuticals. And as far as Daubert goes, we should say this continues to be a really misunderstood and misreported Supreme Court ruling in situations like this. Daubert did two really important but really simple things. Daubert is not complicated, even though we made it out to be complicated. It's not. The first was that it reinforced the authority of the relevant federal or state rules of evidence that apply in a particular criminal case. So what the or civil case. So what the court was trying to do in Daubert was remind everyone that the old Fry standard from 1923 didn't carry as much weight anymore because we have rules of evidence now, which we didn't have in 1923. So all Daubert did was tell the courts, and this was back in 1993, 70 years after Fry, the Daubert court was telling the courts, hey, follow your rules of evidence. That's why we have them. And the second thing that Daubert did was recognize the tremendous responsibility that judges have in evaluating the admissibility of expert testimony, pointing out that judges are lawyers. They are not doctors, they're not scientists, and they're not engineers. They're not accountants. Yet they are put in the position of having to make judgments about things for which they have no expertise. And the court was empathizing with that. So the Daubert court gave them a little help by pointing out some things that judges can consider if they wish to when making a determination about evidence admissibility. Yet these guidelines are frequently misinterpreted as rock-solid standards, where if you don't satisfy each of the 5 considerations that the Daubert court came down with, then you can't admit the testimony. It's like a litmus test. And that's just not true. It never was, never will be. The Daubert guidelines are just that. They're guidelines. They're not standards. They are judicial suggestions that judges can take into account when making these kinds of complicated evidentiary determinations. And just for our purposes here, I'll tell you what those five guidelines are under Daubert. Number 1, can the theory or technique be tested? Is there a history of peer review and publication? Is there a known or potential rate of error? Are there standards controlling its operation or its application? And 5, is the testimony accepted within a relevant scientific community? And that last one was basically what the Fry standard was. It's called the General Acceptance Standard. Now, it just so happens that the Daubert ruling came out during my first year in forensic science, 1993, and it was like a nuclear bomb went off. It was seriously like an end-of-the-world kind of event, at least from a forensic standpoint. But of course, that just wasn't true. Remember that the courts and the judges are not in the business of making determinations about entire fields of endeavor. That is not their responsibility, and it is not even possible for them to do that. Instead, the only thing that our courts and our judges can evaluate is testimony. And all testimony is specific to only one case in one courtroom before one judge. Every other judge in every other courtroom will have to decide for him or herself what evidence they will or will not allow. So we can't fall into the trap of thinking that when these rulings come out, that this will somehow predict how future judges will rule in future cases. So this case out of Oregon, while quite significant in that particular case, it's a big nothing burger on a larger judicial or scientific scale when it comes to evidence admissibility. It only applies to that case. Now, I want to close here by issuing a bit of a challenge and even a warning to our many outstanding pattern identification practitioners out there who give expert testimony in courts of law. And I'm one of them, although I am extremely selective these days about getting involved in cases because I just don't have the kind of schedule that is conducive to the burdens of expert witnessing, which many of you know all too well, just as much as I do. All of us in these pattern identification disciplines have a problem that we need to own and that we need to solve right now because the solution is way overdue, and that's on us. And until we commit ourselves to solving the problem, we can expect rulings like the one that we just got from Oregon. And it's not necessary because it's easy to solve. So here's the problem. Since forensic DNA came on the scene in the late 1980s and the early 1990s, it changed the entire the cultures and the ways of thinking and the scientific sensibilities in forensic science laboratories all over the world. DNA brought a different, I don't know, how would I say this? A more robust and more demanding approach to establishing scientific rigor and scientific credibility. So both in my opinion and in my experience, we failed as communities of practitioners in these pattern identification disciplines to react appropriately to this new era. We failed to establish the kinds of scientific connections that need to be made between a forensic practice area and a relevant, well-established, universally recognized body of scientific knowledge or research. What we did as communities of practitioners in these disciplines was that we doubled down on our history and our training. And don't get me wrong, that was certainly important. Those can't be dismissed because history and training are, in fact, extremely relevant. But the times have passed us by in many ways. Areas of practice have to be seen as having a legitimate scientific home that keeps it connected and grounded to reality, to scientific reality more specifically. It's just not good enough anymore, whether we like it or not, to say that the work I do is reliable because it's been done for so long and because I'm trained and educated to do it reliably. And so, once again, we return to a real fundamental question that we've posed and discussed on this show before, and that is, what is the legitimate scientific home base for the pattern identification disciplines? And we have answered that question. It is stochastics. That's it. Stochastics is the study, measurement, and prediction of random phenomena. The microscopic, I say scratches to use that word colloquially, also called striations or impressions, that allow a cartridge case, for example, to be identified to the gun that fired it, are randomly occurring. They are random phenomena, which means they are stochastic markings that properly trained and properly equipped forensic experts can use to help our courts resolve a wide variety of legal disputes, including criminal cases and criminal trials. But to all of my colleagues out there who are continuing to ignore the field of stochastics, whether by choice or not, and are continuing to, in my opinion, waste the opportunity to make good, robust connections between the forensic pattern identification sciences and the broader field of stochastics, we need to start modernizing these disciplines by getting them connected to their home. These are stochastic forensic patterns. The striations on fired bullets, the impressions on fired cartridge cases, the latent friction ridge patterns that's found on all kinds of crime scene evidence, the wear patterns on the outsoles of shoes or on the tread of used tires, handwriting, and yes, as I said before, the tear of a sheet of paper, the contours of the tear on both sides. All of these are stochastic forensic patterns. And it's my opinion that we need to start calling them what they are and thinking about them as they are. And until we're willing to do that, then I think what we're doing is we're choking off our own areas of expertise from their scientific homes. And it's not fair to these disciplines. And that is not something that any professional with integrity would ever want to do. I think that these amazing pattern identification disciplines need better from us as their stewards. And we owe it to the generations of practitioners and researchers that went before us to keep these disciplines moving forward and not just get stuck where we are, kind of drawing on the same tired old explanations of what we do and why it's scientifically credible. It's just not working anymore. And so what I would like to do is to make this a call to action, and I would like to call for the creation of a stochastic patterns working group at the national level, involving examiners at the federal, state, county, municipal levels, and private, all across the forensic sciences, to begin the process of reinforcing our pattern identification disciplines with ways of thinking that I believe will breathe life into them. And no question, they're reliable right now. They can be trusted right now. When these disciplines are practiced by responsible, properly trained, properly equipped practitioners. But we have an opportunity here to significantly improve how we explain what we do in these areas. And I would also like to call, and this is something I haven't done before and I want to do it now, I'd like to call on researchers and scientists who specialize in stochastic phenomena and stochastic analyses to come to the support of the forensic science community in this way. You folks have a wonderful opportunity to get involved in a very interesting conversation that could be of historic significance to our courts, not only in the United States, but all around the world. And if you'd like to, you can reach out to me directly at john@criticalvictories.com if you would like, and I would be happy to facilitate, to the extent that I'm able to, your involvement in some of the outstanding research that continues to be done in these classical forensic disciplines. These are communities, and I use that word very intentionally, communities of forensic experts who have a lot to be proud of. With only very few exceptions, these are professionals who do outstanding work and are very important to the cause of justice and to the cause of public safety, just as our colleagues in the instrumental disciplines are, such as our DNA analysts, our toxicologists, our drug chemists, and so forth. And I'm working on some ideas of my own for how we can bring our pattern disciplines into connection with the broader field of stochastics, and I will definitely keep you posted on those efforts. So, again, there's nothing to fear or nothing to be angry about with this ruling out of Oregon. And I will include some links in the program notes. But there continues to be an opportunity to breathe new scientific life into these well-established and historically robust forensic disciplines that have done so much for our criminal justice system and will continue to do so much for our criminal justice system in the years and decades and even centuries to come. So thanks for listening to this special edition of Crime in the Courtroom. I'm John Collins, and I will see you next time. Thanks, everybody.